Good afternoon. My name is Megan Brown, and I'm an outreach officer with the U.S. Department of State, Bureau of Consular Affairs. One of the responsibilities of my bureau, which is the Bureau of Consular Affairs, is to educate and ensure that law enforcement are aware of and carry out consular notification and access, or CNA, procedures when a foreign national is placed in their custody in the United States. We have found the best method of ensuring compliance is through education. We recognize that many law enforcement agencies may not arrest foreign nationals on a regular basis and may not even be familiar with CNA. It is our goal that by the end of this training that you will know what CNA is and why it matters. Here's a summary of what we will be covering during this training session. So, a little bit about us. The Bureau of Consular Affairs has no higher priority than to promote the safety and security of U.S. citizens abroad. Across the globe, we serve our fellow citizens during some of their most important moments: births, adoptions, medical emergencies, deaths, arrests, and disasters. We also help U.S. citizens connect with the world by issuing millions of U.S. passports each year. So, getting right into it, what is consular notification and access? Well, quite simply, it's the process of informing a foreign government representative of the arrest, detention, or death of a foreign national and allowing the government to communicate with its nationals in detention. The foreign government representatives are normally consular officers. Consular officers assist and protect citizens of their own country when those citizens visit a foreign country or live abroad. This is important for all of us as Americans because this is a two-way benefit. The United States has consular officers in over 200 embassies and consulates around the world to assist U.S. citizens who need help, including when they are detained by foreign authorities. To illustrate that point, the map that you're seeing on the right-hand side of your screen is a map, an interactive map that we have on our website at state.gov that is interactive, and you can see where all of your embassies or consulates are located throughout the world. So you see France, Germany, Spain, and parts of Africa as well. In addition to the legend that shows you all of the different stars and squares and things like that, and also the colors as well indicate travel advisory. So yellow would be exercise increased caution, and red would be do not travel, so on and so forth. So in regards to assisting foreign nationals that are detained, or assisting U.S. nationals that are detained by foreign authorities, consular officers, they can only provide assistance to those detained persons if, one, they know about the detention, and two, they are allowed access to the detainee by local officials. These procedures are what make up consular notification and access. These consular notification requirements are set forth in numerous international treaties and agreements, most prominently in the 1963 Vienna Convention on Consular Relations, a multilateral treaty to which the United States and more than 170 other countries are party. These treaties are binding on federal, state, and local government officials. In other words, they're the law. So why do we go to such great lengths to ensure we are complying with these procedures here in the U.S.? As I mentioned, not only are we a nation that meets our legal obligations, but by doing so, we help ensure that Americans abroad receive the same consideration from foreign governments. Millions of U.S. citizens travel and work abroad every year. If they are arrested, U.S. citizens rely upon the U.S. State Department, through our diplomats and consular officers posted overseas, to assist them. To do that, U.S. consular officers need to be notified and have access to those arrested to ensure that they have adequate food and medical care, are able to contact friends and family, and have access to an attorney. If you remember only one thing from today's presentation, let it be this: the way we treat foreign nationals here in the United States can and does affect what happens to U.S. citizens who are in trouble abroad. That is absolutely crucial to understanding why we must carry out CNA procedures domestically. Under these international treaties that contain CNA requirements, U.S. citizens detained abroad have the ability to have a U.S. consular officer notified of their arrest, but U.S. citizens in that situation may not know about this option unless the arresting officer tells them. The same goes for foreigners arrested here. Not every foreigner traveler knows this. Somebody has to tell them, and that would be the officer who arrests them, which could be you. Honoring our obligations here at home is important for the safety of Americans abroad. Consular notification and access obligations apply to all foreign nationals in the U.S. So, who is a foreign national for CNA purposes? Well, any person who is not a U.S. citizen. This includes short term visitors, lawful permanent residents or green card holders, and undocumented foreign nationals. By the way, many U.S. citizens also have another nationality. Consular notification and access obligations technically do not apply to dual national U.S. citizens. However, we ask that you notify the consul of the other country as a courtesy. We would want to know when U.S. citizens who are dual nationals are arrested in any other country, so we need to do it here to expect that from authorities abroad. A consular officer is an official of a foreign government accredited by the U.S. Department of State and authorized to provide assistance to that government's citizens in another country, regardless of whether a consular officer is assigned to an embassy in Washington, D.C., or to a consular office maintained by the foreign government at another location in the U.S. So, what are the CNA requirements when you arrest or detain a foreign national? Well, it depends on the treaty that we have with each country. There are 57 mandatory notification countries. Notification to the consular officer must be made whether the arrestee wants it or not if they are a citizen of these 57 mandatory notification countries. If the detainee asks you not to make the notification, you should explain that you have no choice. It is a legal requirement. The notification requirement should still be honored if a detainee has applied for asylum, but do not disclose any information related to that application to the foreign embassy or consulate. If a consular officer insists that they are entitled to the information about a detainee that the detainee does not want disclosed, please contact the State Department for guidance. For all other countries, the requirement is that you must offer to notify the arrested foreign national's consulate. The foreign national can accept it or turn it down. In any event, keep a record of the person's response. This is important in the event that there's any question regarding consular notification. Allowing an arrested or detained foreign national to call his or her consular officer does not qualify as consular notification. Notification must be made by the arresting or detaining law enforcement authority to fulfill treaty requirements. Now, for the notification procedure. Notification must be offered and or made within 24 to 72 hours after the initial arrest. So again, looking at the timeline that we have here, if they are from a mandatory notification country, definitely notify without delay. If not, ask the detainee if they want notification. If they do, notify without delay. And again, keep those good written records of who you notified, the detainee's decision, date, time, and method of notification. The longer the detention continues, the more likely it is that a reasonable person would conclude that the notification obligation is triggered. Even if the national is only detained for a few hours, go ahead and make or offer notification. It's better to be safe than sorry. And if the foreign national has been arrested for an offense where it's obvious he or she isn't going to be released anytime soon, go ahead and make or offer notification as soon as you can. For making momentary stops, like writing a speeding ticket, notification is not necessary. You're not requiring the person to go with you to a place where they will be held or be arrested. As for how you notify the consul, well, believe it or not, the fax machine works 24/7, and the fax confirmation sheet provides a written record of notification. You can provide notification by email to most foreign embassies, and the copy of the notification email that you sent is also a good written record that you sent notification and also works 24/7. Keeping good records is critical. It is essential not only to provide notification, but to document it. In the event that the that the detainee's attorney, or foreign government later claims that no offer to make consular notification was made or notification never happened, you have proof. If you notify in any other way than by fax or email, such as by telephone, make a note in the file of the time, date, number you called, and the name of the person you spoke with. Here's a list of those 57 mandatory notification countries I mentioned earlier. If you're aware of anyone coming to your jail or prison that is from one of these countries, ensure that during intake they have been made aware of CNA and that by law you will notify their nearest embassy or consulate that they are now at your facility, whether that be jail, prison, or police department, whether they want you to or not. The foreign national does not get a choice in this. If the foreign national is not from a mandatory notification country, you must offer to notify their nearest embassy or consulate. If they ask you to notify, you must do so. And Mongolia is also listed here. It did not make the list at the time of this publishing, but Mongolia is also, that's that 57th mandatory notification country. In addition to when an arrest or excuse me, in addition to when arrests or detentions, consular notification and access obligations are also triggered by these following situations. When a foreign national dies, when a foreign national minor is incapacitated, or an adult that is incapacitated in custody requires a court appointed guardian, minors being placed in foster care or trusteeship, or adults with Alzheimer's, or persons off their psych meds, to name a few, and when there's a plane crash or shipwreck in U.S. territory or U.S. waters. In the case of serious accidents or major disasters, the competent authority who needs to make notification will vary, but officers who may find themselves involved in such incidents should make every effort to ensure that notification is provided. Though serious injuries are not specifically covered in the VCCR, the Department of State encourages U.S. officials to make notification in any situation where a foreign national is in such a critical condition that they cannot communicate for themselves, and contacting consular officials would be in that person's best interests. For example, if they are in a coma, in the ICU, etc. Notification in the situations I've just described should be provided in the same way as notification of an arrest or detention, by fax, email, or phone. So, consular notification and access obligations provide consular officials with the right to have access to their nationals. They can visit, call, or write. Whether they choose to do so and how they choose to do it depends on the traditions and resources of the country and the location of the nearest consulate. Some of the services that consular officers provide for their nationals are listed here. So they can arrange legal representation, monitor case progress, provide reading material, food, medicine, inquire about detention conditions, and also updating family members as well. Consular officers are expected to follow regulations of the detention facility regarding security and the time, place, and manner of visits, but regulations should not be so strict as to prevent consular access. We urge the authorities to grant consular officers liberal access to detained persons, providing them every courtesy consistent with local laws and regulations. Liberal visiting privileges are particularly important when consular officers have to travel long distances to visit their citizens. Again, I can give a quick example of this when we got a complaint from the Ghanaian embassy here in Washington, D.C. They wanted to visit a foreign national that was in a supermax prison in Colorado. And they wrote to us upset because they believed that they were being denied consular access. When we called the supermax prison, they informed us that the Ghanaian said that they did not want to fill out the necessary paperwork that is required for background investigations or background checks of the individuals, the consular officers that wanted to visit that person. So we determined that that was not a denial of visitation. It was simply the Ghanaians did not want to follow proper procedure that was still allowing access to their national, but they had to follow those local laws and regulations. So if you do have any questions about that, please feel free to contact the State Department if you are getting individuals that consular officers that claiming to not be able to access their nationals at your facility. And again, just remembering reciprocity. What access conditions would you like an American consul to have if visiting a relative of yours under arrest in a jail overseas? So, consular officers are not permitted to practice law in the US, but they should be given the same communication privileges as defense attorneys. Consular officers may not interfere with criminal investigation or judicial process. And it is not necessary to delay an interview or interrogation to make consular notification or to wait for a consul's arrival. All right, almost done. Okay, finally, why should you care about all this? Well, quite simply, it's the law. The Supremacy Clause in Article 6 of the US Constitution makes CNA the law of the land. We want to uphold our international agreements so that we can protect US citizens overseas. If we comply with our international agreements, other countries are more likely to do so. CNA compliance also helps avoid legal challenges. Defense attorneys may attempt to challenge prosecutions based on failure to provide consular notification. Some judges may even find the appropriate remedy for a CNA violation is to have evidence suppressed or convictions even overturned. Some US states are instituting legal remedies in the event that of lack of consular notification. Massachusetts, for example, provides for a new trial if lack of notification is seen by the judge as prejudicial against the foreign national's case. California, Oregon, and Illinois also have consular notification laws. So, why take the chance on this? Following CNA procedures is easy, and keeping records of notification avoids creating grounds for challenges of convictions and sentences. Also, foreign consular officers can help you. They know the language and the culture of their nationals, can contact relatives, and be a general resource for you. Your efforts are critical to protecting US citizens overseas. When we have trouble with the host government, we can honestly point to your hard work in making sure that that country's citizens are given proper consular notification and access in the United States. So here's a few of those reference materials that we have available on our website. It's travel.state.gov/CNA. Going down the line here, you have the Consular Notification and Access Manual, which is the blue icon to your left. That is essentially the Bible equivalent to everything CNA, has frequently asked questions, and also the mandatory notification countries, and also just statements as well that you can read to foreign nationals when they come into your custody. In the middle, we also have the flow chart for arresting a non-US citizen that also has the list of mandatory notification countries in the middle there in that navy blue section. And then to the at the very end on the right-hand side is the mandatory notification and just consular notification statement in several of the most common languages spoken. So if in the event that foreign national does not speak English, you can simply point to that statement and they can read and understand their ability to have their embassy or consulate contacted if they wish, if they are from one of those optional countries, not non-mandatory notification countries. Okay, and this essentially concludes the consular notification and access training for the New Albany Police Department. These are some ways that you can get into contact with us. We do check our email quite often throughout the day, so please feel free to reach out there. It is CONSNOT. I did not make that up. It was here before I got here, but it is short for consular notification. So that is consnot at state.gov. Our after hours telephone, that is for diplomatic security. So if at any point you make an arrest and no one is available at that constant email inbox to respond to you, if you give that phone number a call, they can get you routed to the correct people to get your whatever questions that you need to be answered. And then, of course, our website at the bottom there that has all of those resources that we mentioned earlier. And if you would like even physical copies of those resources, we can also send those to you as well. Thank you so much for your time and attention, and I hope you enjoy the rest of your day.